Injunction, preliminary. Injunctions are classified as 1, temporary or preliminary, and 2, permanent. This section deals with preliminary or temporary injunctions. The next section deals with permanent injunctions, typically granted to continue preliminary injunctions after plaintiff shows the necessity of making the preliminary or temporary injunction permanent. All injunctions derive from the inherent equitable power of courts to issue writs and warrants to sheriffs or other law enforcement officers who then have legal authority to use force if necessary to carry out the court's orders. Injunctions enjoin action, i.e., they either order that action be taken or that it is not to be taken. Injunctions are used in many and varied circumstances to affect a court's judgment. Temporary injunctions are typically entered or denied at the start of a lawsuit in which the plaintiff seeks some remedy for damages he has not yet proven. Elements: 1. Imminent likelihood or irreparable harm if a temporary injunction is not issued. 2. Unavailability of adequate remedy at law, i.e., an award of money damages alone will not restore the plaintiff's threatened loss. 3. Threatened harm to plaintiff petitioner outweighs any possible harm to the defendant respondent. Petitioner and respondent, again, are words that I really love. It's what I put in my writs, in my claims. I don't file complaints, ladies and gentlemen. Men make claims. Corporations file complaints. We file as petitioner and respondent. We don't use plaintiff and defendant because that falls underneath of filling an office or being an officer of the United States, right? We find that in Federal Rules of Civil Procedure, I believe it is 17, if my recollection serves me correctly. 4. Granting of injunction will not contravene the public interest. And 5. Plaintiff petitioner has a substantial likelihood of success on the merits of underlying cases, i.e., the cause for which plaintiff seeks an injunction is likely to be proven. The granting of a preliminary injunction is an extraordinary remedy that should be granted only sparingly upon presentation of adequate proof of the essential elements. Now, let's just talk about this real quick. I know somebody who has a permanent injunction in the state of Florida against the DMV and against all agents and agency for him traveling to and from in his pleasure, in his leisure, in his private household consumer good. That injunction still stands today. It's permanent. They do not mess with this man. I don't care if he's doing 105 down the road. If they stop him, they simply say, hey, is there anything we can do to help you? Sorry to inconvenience you. We just stopped to see if you needed any assistance. They don't even bother to tell him to slow down. Now, by getting that injunction, he articulates that we should be mindful of other people. Yes, the injunction works. Yes, the reason he was doing that was just to see if it worked. It worked. After that, he obeys or follows the principles of the road, so as not to put people in danger. He's never going to go flying through a school zone because it's incomprehensible. It's absolutely ignorant to do such a thing, right? He's not going to run around drinking and driving because it's willful disregard for other people's life. It's wanton disregard for other life as well as his own, right? So he doesn't partake in those things. Needless to say, the permanent injunction is bad to the bone. And again, it's likely to be granted so long as it doesn't affect the public. Well, him traveling doesn't affect the public at all. He's not engaged in commerce. He doesn't have license plates on his automobile. He's got a permanent injunction in place, and he just simply serves it upon anybody that stops him. Hey, here you go. Here you go. This is me. Okay, no problem. Have a nice day. Defense, unclean hands. An injunction, being an equitable remedy, should not be granted when the party seeking it has not acted in good faith, i.e., giving due process of law and proper notice, right, to the governor, secretary of state, attorney general. This is when this gentleman did this down in Florida, he put everybody on notice in good faith. Hey, here's my reasons for wanting an injunction. Speak now or forever hold your peace. If you don't speak up now, I'm going to give you one more bite at the apple when I file into the court for my equitable injunction for permanent for a permanent injunction for equitable relief to make sure that I'm not accosted against my will by any more of your gun-toting morons with an IQ of less than 70. And guess what? It was granted. Okay, the governor didn't show up, the DMV director didn't show up, the Secretary of State didn't show up, the Attorney General didn't show up. Nobody showed up to contest it. So what'd the court say? Shit, we don't have a problem giving you that. There you go. Here's your permanent injunction. May they forever leave you alone while you peacefully prosper and do your best to do the good works of the Heavenly Father. The maxims in equity is he who comes to equity must come with clean hands. Thus, if a plaintiff petitioner has wrongfully defrauded the defendant respondent when he seeks an injunction, the court should deny him. If the respondent pleads unclean hands as an affirmative defense and explains in his pleading why the plaintiff petitioner has unclean hands totally of the circumstances, the court should not merely consider the allegations of the pleading when asked. To grant an injunction, other factors should be considered. 1. Nature of the interest to be protected. 2. Relative adequacy of others available less restrictive remedies. 3. Unreasonable delay of plaintiff petitioner to seek the remedy. 4. Relative hardships likely to be caused to defendant respondent. 5. Possible prejudice to defendant respondent of defending in underlying lawsuit. 6. Related misconduct of plaintiff petitioner. 7. Interest of third person and of the public. 8. Practically of framing and enforcing the injunction. Comments. Bond. Some jurisdictions require the posting of a bond to protect the foreseeable injury to defendant respondent. The amount of the bond is calculated in relation to the amount of money damages a wrongfully issued injunction might cause the defendant respondent. In some jurisdictions, if the court does not require a bond and no bond is posted, the injunction cannot be lawfully enforced. Check local statutes and case law. Breach of contract. Injunctions typically do not issue to enforce contracts. The proper action is for specific performance, covered elsewhere, in which case, if sufficient proof is shown, the court may issue an injunction to require the defendant respondent to perform provisions of a legally binding contract. Covenant not to compete. Non-compete provisions in written agreement, ergo contracts for employment, are typically enforced by injunction. If sufficient proof is shown, restrictions apply if service of the party to be enjoined are of particular value to the community, ergo doctors or other medical service providers. Further, if the conditions of the covenant, ergo length of time or size of the geographical area, are unreasonable, courts will not enforce the covenant. Injunctions to prevent unauthorized use of trade secrets or solicitation for proprietary customers list are typically granted. Domestic violence. These are generally related to statutory enactments that define the procedures and preconditions necessary to obtain an injunction to prevent violence. See local statutes and case law. Evidence. As stated elsewhere in these and others material, mere argument of counsel does not constitute evidence and is insufficient grounds for issuance of an injunction, temporary or otherwise. Again, that's Trinsley versus Pagliaro. All right. Statements made and arguments are brief, although entertaining to the court, do not grant rise for the court having jurisdiction to make a summary judgment. Futile act. No court's process can lawfully enforce the performance of a futile act. If requiring or prohibiting any action, an action will have no reasonably foreseeable benefit, the court is without jurisdiction to lawfully enter an order. Irreparable harm. If the wrong sought to be prevented by an injunction could be compensated by an order awarding money damages to the injured person, an injunction should not issue. The decision is not based on whether the defendant respondent possesses sufficient means to satisfy the money judgment, but whether money alone would, if available, restore plaintiff petitioner to his original status. If a money amount cannot be calculated to restore the injured party, an injunction is proper. Injunction permanent. To obtain a permanent injunction, one is generally required to offer a much higher degree of proof and clearly demonstrate necessity. Further, where a temporary injunction may issue without notice of a hearing, a permanent injunction can only issue after notice and pleadings have been served on the defendant respondent, who must be given a reasonable opportunity to respond and present evidence in defense. Now, I was telling you earlier, my buddy down in Florida has a permanent injunction against the DMV. He involved the governor, the Secretary of State, and the Attorney General, and got a permanent injunction so he wouldn't be harassed by gun-toting morons while exercising his right to locomotion to go to and from where he pleases in his private household consumer goods, his private automobile, without registration, without insurance, and all this other stuff. Now, he did something really cool where he created his own negotiable instrument that is registered with the county, okay? And so he is insured. It's just a different way of going about it. It's not something typically that people talk about. He insured himself, okay? He's got a bond on record, on file, that covers his automobile should he be involved in an accident or an incident where they can liquidate that bond and make the other party whole. The elements are the same, but for one additional essential: success on the merits of the underlying case, see provision section. Elements: imminent likelihood of continuing irreparable harm if permanent injunction not issued. 2. Unavailability of adequate remedy at law, i.e. an award of money damages alone will not restore the plaintiff's threatened losses. 3. Threatened harm to plaintiff petitioner outweighs any possible harm to defendant respondent. 4. Granting of injunction will not contravene the public interest. 5. Plaintiff petitioner has prevailed in the underlying case, i.e. plaintiff has proven the fact on which he seeks the permanent injunction. The granting of a permanent injunction is an extraordinary remedy that should be granted only sparingly upon presentation of adequate proof of all essential elements. Defense: the defense for a permanent injunction are the same as those for a preliminary or temporary injunction. Intentional infliction of emotional distress. This is something that I would say CPS is absolutely fucking guilty of, okay? But keep in mind, at some point you entered into a contract with these blood-sucking fucking vermin that are sucking the life out of you and unjustly enriching themselves under the guise that they're there for the best interest of the offspring, all right? Cancel that fucking contract. It's unconscionable. We're going to talk about that a little bit later here in this this informational guide. Intentional infliction of emotional distress. The gist of this cause of action is to compensate victims of conduct that inflames the sense of human decency, whether inflicted intentionally or with a reckless disregard for the consequences to the other. Elements: 1. The defendant's acts were performed intentionally or with reckless disregard. 2. The defendant knew or should have known the acts would foreseeably cause plaintiff severe emotional distress. Okay, again, CPS. Okay. 3. The conduct was outrageous, indecent, atrocious, odious, uncivilized, or intolerable. 4. Plaintiff suffered severe emotional distress as a direct result. Defense: legal rights. The thin line in these cases is whether the defendant was within his legal right to act in the manner that caused injury. This is always a judgment call for the court. Clearly, if a fraudulent home if a funeral home incinerates Aunt Betsy's mortal remains, and Sister Sue is outraged that such a procedure was used instead of cemetery interment. The funeral home has a defense in that it acted within the legal limits of the law. On the other hand, if the funeral home dumps Aunt Betsy alongside some lonely country road in southern Alabama, the act is one our courts will deem outrageous, indecent, atrocious, odious, uncivilized, and intolerable, so that the family members and loved ones will have a cause of action between these limits is a broad and uncertain gray area only courts can decide. See local case law for help. Defamation. If the only cause of injury is defamation and the defamation falls within one of the privileges, see defamation, plaintiff cannot prevail. For example, if a prominent politician is accused of being a ne'er-do-well, slithering skunk with ties to the underworld, even though the scurrilous, atrocious, well, we're just going to turn that word into atrocious attack. Atrocious attack offends or even causes emotional distress. The politician cannot prevail because of the privilege unless he can prove actual malice. Invasion of privacy. Like defamation, this cause of action can bring more problems to the plaintiff than merely letting the matter go by far. For litigation only tends to republicize facts that may be better left alone. Still, the cause of action exists and the essential elements follow. Again, this is invasion of privacy. Elements. To properly state a cause for invasion of privacy, the plaintiff must allege: 1. Defendant publicized a matter concerning the private life of plaintiff. 2. The matter would be highly offensive to reasonable persons. And 3. The matter is not one of legitimate concern to the public. And 4. Plaintiff suffered damages as a direct result. Everyone has a right to enjoy his or her privacy. This right of privacy has been interpreted from the U.S. Constitution by the Supreme Court and is specifically protected by the state constitutions of many of the 50 states, where a person's private life begins and his public life leaves off. Of course, are decisions for the court in each individual case. When the unwarranted publication of private affairs with which the public has no legitimate concern cause mental suffering, shame, or humiliation to a person of average sensibility, the cause of action arises and the plaintiff is entitled to recover money damages. Some jurisdictions have carved out 4 situations that give rise to this cause. 1. Intrusion, ergo, photographing plaintiff sunbathing in her own backyard behind a privacy fence. 2. Public disclosure of private facts, ergo, publishing the existence of a great wealth that exposes plaintiff to foreseeable injury at the hands of thieves and con men. 3. False light in the public eye, ergo, publishing false facts about plaintiff, a variant form of defamation. And 4. Commercial exploitation of property value of plaintiff's name. Defense, public right to know. If the public has a right to know some matter that would otherwise be protected by plaintiff's claimed privacy right, the cause of action does not arise. If, for example, a local physician suffers from severe cocaine addiction, the public has a right to know, and the physician would have no right to sue those who published such a private fact. If the publication is untrue, of course, the physician has a cause of action for defamation. Hypersensitivity. The measure of sensitivity that gives rise to the cause of action is that of a man of reasonable sensitivity. A person of unusual sensitivity is not protected. When we come back, we're going to talk about latches. We're going to get into malicious prosecution. We're going to delve into negligence. We're also going to talk about quantum merit, MERUIT, merit. So that's what we'll come back with. Negligence, malicious prosecution, and latches. Thanks for joining me, and thanks for all your support.